Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's lockdown edition question is, if I have to go bankrupt, what happens to the company that I'm a director of? Does it automatically go into liquidation? So the answer to this question is no. Just because a director of a company goes bankrupt doesn't mean that the company goes into liquidation at all. Now, if the company has to go into liquidation and the director has to go bankrupt, it's generally my recommendation to put the company into liquidation first. One of the main reasons for this is that when somebody does go bankrupt, they are no longer able to be a director of a company, which means they'll no longer have the powers to convene the meetings required in the company in order for that liquidation process to happen. So before they're bankrupt and while they still have their powers as a director, I generally recommend that they use them to put the company into liquidation if time allows in their particular circumstance. The other thing is, the person who's the director is recognized as a separate legal entity to the company itself. So just because the person has debts that they can't pay doesn't necessarily mean the company has debts it can't pay, and vice versa. Now, sometimes it's the case where both end up with debts that they can't pay, especially if, say, the director signed a personal guarantee for the company's debts and now neither of them can pay the debts. But one doesn't automatically mean the other because they are two separate legal entities. I hope that helps.